Good morning, everybody, and welcome back to Coffee with Craig, where we talk about all things firearms policy, politics, culture, media, you name it. We're talking about it right here on Coffee with Craig. So please take a moment, like and share the program so that your friends know where the conversation is taking place. Also, if you haven't already done so, remember to subscribe to our YouTube channel. Follow us on Facebook, follow us on Instagram and Twitter, and remember, especially in the case of Facebook and YouTube, make sure you hit the notification button. That way, you'll get notifications as soon as we go live, and you'll be able to participate in the live chat as the program is going on. Also want to encourage you, if you haven't already done so, please make sure you visit fpcgear.com. It is the place to get all of your Pro 2A swag. I'm talking about t-shirts. I'm talking about tank tops. I'm talking about ladies gear. I'm talking about all of the accessories that you need, up to and including make sure you get a warrant welcome mats for your front door. Make sure you guys do that. It's all there at fpcgear.com. We're always uploading new designs and new stuff. So make sure you guys check it out. That's fpcgear.com. Now, you guys all know, if you're someone who watches the show, who's watched the show on a regular basis, you know that for us, we recognize that the Second Amendment is not treated like every other right. In fact, it's treated more like the redheaded stepchild of the constitutional rights. And to talk a little bit about that, we wanted to bring on board an individual who all of you know very, very well. It's Mr. Matt Larosiere, who is the Director of Legal Policy with the Firearms Policy Coalition. Matt, how are we doing today?
What's going on, Craig DeLuz?
Man, look, it has been a while since we've been on the program together.
It sure has, man. How you been?
Man, I am glad to be back. I'm glad to be
once again. Have you back, man.
It's always fun. I definitely enjoy having coffee with you. That is for sure. So, all right. So we all know that or at least we all believe that the Second Amendment is treated differently from other rights. Maybe you can just start and kind of go through some of the ways in which the Second Amendment, in particular, whether it's by politicians or by the courts, talk a little bit about some of the ways that the Second Amendment is treated differently from our other civil rights.
Well, I mean, insofar as it's treated differently by politicians and, talking heads and whatever, I mean, it's pretty easy to talk about there. They just don't actually consider it a right. Everything that generally politicians talk about, it's always, oh yeah, but. So that's completely inconsistent with the concept of a right. There is no but with rights. So it's most interesting to look at the way the courts, who are, really the same type of people who are writing these decisions, or people who don't believe that it should be there, are trying to write around it. So as you've often heard, discussed in a lot of articles, a lot of stuff we've written, there really hasn't been a clear standard of review put down by the Supreme Court for how we handle Second Amendment violating laws. We know that these laws violate the Second Amendment, but the lower courts are just up in a tizzy about what to actually do about it. Where's the lines, where are the thresholds and stuff like that. So a lot of times they import standards of review from like the First Amendment. And I think that's a pretty appropriate thing to do, right? We have a robust First Amendment, and we ought to have a robust Second Amendment. So those analyses should apply. Well,
let me interrupt you real quick, and because I think this is important. A lot of people don't understand when you talk about the analysis. I mean, what are some of the different types of analysis, like strict scrutiny versus rational basis, and why is it so important that there be either a consistency or what? Why is the difference important?
Okay, so this is really important, and I'm glad you brought that up. And something I really don't like talking about it because it's all a bunch of crap. So these tiered standards of review are actually, that in law school they'll tell you this is how it's always been. This is how you analyze rights in the Constitution. It's actually only been around for a few decades. It originates in a footnote in a case called Caroline Products, but we won't get too deep into that. So basically, they've set up 3 tiers of review. Tier 1 is rational basis review, where basically the court will go back and say, oh, well, did the government have a rational basis for enacting this law? And it doesn't have to actually, the government doesn't have to actually have acted on the rational basis. It's whether the court could even imagine that there is any rational reason to make that law. So basically, that on that tier, the government wins, no matter what. Then there's intermediate scrutiny, right? Which is let's talk about strict scrutiny first, because strict intermediate fits in between the two. Strict scrutiny is, right, is there a compelling government interest? So like, is there something here that the government absolutely has to accomplish? And then, is the means which the government chose to accomplish that compelling interest the narrowest way to achieve that interest? And so basically, this is the government loses. It's really hard to do this because the government, they're never able to only take what they need. They always want to take, the whole pie. So there's strict scrutiny, which is basically, that's how it should be applied every time you have a state violating your fundamental right. That's pretty much the only standard of scrutiny that should exist at all. So then in between, we have intermediate scrutiny, which is stuff like, is there a very important government interest, and is the law sufficiently narrowly tailored, right? Is it like, does it not take way too much more than what's really necessary? Are there other less burdensome alternatives? Right. Those are the kind of questions you ask in intermediate scrutiny cases. And some examples of intermediate scrutiny cases are like, if your city has a ordinance to where you can't have a parade after 10 p.m., right? Stuff like that. Those are called time, place, manner restrictions, and they fit under intermediate scrutiny.
Okay, so now the one that's most interesting to me is this idea of rational basis, right? This idea that not only does the state or the government not only do they not have to prove it, they can just come up with just anything as a rational basis. Even if the government doesn't think of it, if the court thinks it up, they can literally pull it out of nowhere.
Right.
And
so I could,
yeah, go ahead.
I could pass a law saying you can't serve spaghetti past 5 p.m.
Right.
And I could write in the in the abstract of the law, I could write in the law itself saying something like, because it cannot rain in April, and the sky is green every Thursday, and the floor is lava, only walk on white tiles, you may not, sell spaghetti after 5 p.m.
Mm-hmm.
And like the court could just go, well, it might be that, it's dangerous after 5 p.m. Or like they might imagine that,
there might be a disproportionate amount of heartburn if you eat spaghetti after 5 p.m.
Exactly.
And they just decided that's now a rational basis for the law.
Right.
How often would you say that really bad anti-gun laws are upheld by the courts based on rational basis?
So that's interesting. So how often are they actually upheld by the courts on rational basis, or how long, in effect, or how often does the court apply rational basis to gun laws?
How about both?
Okay, so how often do they say they're doing it? Very rarely anymore, right?
Mm-hmm, right.
Very rarely nowadays do they just straight up say, whatever, And basically, once you get to rational basis zone in gun law means, this could possibly help gun violence. And that's all you need, right? It's like a talisman, gun violence, the gun violence talisman. They shake it and then the law gets to stay.
I like the gun violence talisman.
Yeah. So just remember that.
Boogie.
Yeah. Woo, and the law stays. So remember, that's what rational basis looks like. So then what they do is they purport to apply intermediate scrutiny, or they purport to apply some level of heightened scrutiny. And then if you read the analysis, pretty much all they're doing is going, ooh, with the gun violence talisman and saying it satisfies heightened scrutiny. So in actuality, rational basis is used constantly in the gun context, but they're not calling it that. And the fact that they're not calling it that, and they don't even really look at what the government's saying, because the government just goes, well, gun violence. And then the court goes, ooh, and holds it up. So that's really damaging, not only to our Second Amendment rights, but to all of our other rights. Because then in the future, like in a First Amendment context, you'll say, oh, well, the court applied, the same reasoning here, the same test here, and they held that it was sufficient just, to invoke a talismanic fear of violence. So that's why we should be able to ban spaghetti after 5 p.m.
Okay,
right?
so let's take it to this next step. So let's now compare the type of scrutiny that's generally used for Second Amendment cases and compare it to First Amendment cases. How is it different?
Well, so in the First Amendment, like if I just pass a law saying you're not allowed to, praise God or whatever, right? Which is just a straight up, you're not allowed to do this. And it's remember, I'm telling you can't do it a specific way. I'm not saying you're not allowed to speak. I'm saying you're not allowed to praise God or sing this verse of Nickelback, right? That would be strict scrutiny because the court would be like, well, no, you're just straight up banning speech. Like you're just straight up banning it. This isn't limited to time. This isn't limited to a certain way. It's not calculated, right, for a specific public good. You're just banning something. So no, you can't do it. Whereas in the Second Amendment context, all the time they say, well, you can't have that gun, right?
Right.
This gun, the G3, is a specific Second Amendment exercise, right? It just those other things are a specific First Amendment exercise. I think using this gun with its standard magazine is a normal Second Amendment exercise, right? And in California and other states, they just straight up ban it. But they work backwards to get, it's actually that's a specific type of restriction. So it's really more like the time, place, and manner when it's not the law doesn't say you can't use an assault rifle to commit a crime. The law doesn't say you can't use an assault rifle on Thursdays between 3 and 5. They just say if you have this, you're going to jail.
Right.
So that's a complete different thing. In the Second Amendment context, states have gotten away all the time with doing categorical bans on types of Second Amendment expression or types of Second Amendment conduct without having to really pass a bar.
Right. It's funny, and I always use this example, and when in terms of how rights are treated differently, I'm sure you've heard a million times you can't yell fire in a crowded theater, and you and I both know that you can, especially if there's a fire. But the real difference in this particular case comes in is that the way in which gun laws are treated. If we applied the same standard of gun as we do gun laws, it would be like putting duct tape on people's mouths and basically gagging people before they go into the theater, just to keep them from potentially being able to break the law.
And the other thing about the fire in the crowded theater example, that's not about speech.
Right.
It's about causing tortious harm.
Right.
Right. It's about if you yell fire in a crowded theater and you then cause, a trample and stuff like that, you cause a stampede. It's not about your speech.
Right.
It's about your conduct, which then caused damages, right?
Right.
And so it's basically that, you can't ban the speech. What you can ban is the nefarious acts and I know people will say nefarious acts with gun. No, it's not the same because remember, it's ex post. We're talking about what happens after, what your intention was. So the fire in the crowd theater thing isn't saying you can't say those words. It's saying if you say those words when it's inappropriate, you may be held responsible.
Exactly. So in other words, if you in the expression of your right, your civil right, you abuse it, and by you abuse it, there are both civil and criminal penalties, ways in which you can be held accountable. And the same thing, by the way, exists with gun laws. If you use a gun to rob somebody, guess what? There's laws against that. If you use a gun to murder somebody, guess what? There's laws already against that. So why do you
and not even that.
Yeah, right.
But civil, let's talk civil is where it's really interesting, because you can be civilly liable for exercising your rights. You can if they, reasonably you should have known would cause damage in certain consequence. And that applies to guns. And actually, since the 1600s, it's been known that whenever you fire a bullet, liability attaches to that bullet. And wherever it goes, you're responsible for that. So, if you're on your property or, whatever, or you're celebrating and you shoot into the air and you didn't intend for the bullet to go anywhere, but you have to be responsible for those projectiles. And so that's kind of why the common law, dating back all the way to the 1600s, really takes care of everything that gun control is trying to take care of. It's if you do something irresponsible with your gun, you can be held to account for it. That has never changed, but the politicians want to pretend like we're living in the Wild West and we can just mag dump wherever we want without worrying about it. It's not the case. It's really never been the case.
Wow, that's phenomenal, man. And it's so, folks, this is the reason why it's important that you support groups like the Firearms Policy Coalition, like the California Gun Rights Foundation, like the Firearms Policy Foundation, Firearms Policy Coalition. It's important because here's the thing. These things are all being fought out in court, and these definitions are being redefined in court. And if we're not there fighting, and with all due respect to the other gun groups, there is none that I know that is more specifically dedicated to the idea that the Second Amendment is a fundamental right enumerated in our Constitution. It's not granted to us by our Constitution. It is a fundamental human right, and it's in our Constitution and needs to be fought for as a fundamental right. And the work that FPC does in that is, in my opinion, second to none.
You're making us blush.
I try. So do me a favor. Let the folks know how they can follow the various different legal cases and the work that you're doing with FPC.
It's all on firearmspolicy.org. As a lot of you know, every week I do a video update, and there's also a written version that has links to all of the stories and everything. You can find that on fpcnews.org. Of course, check out the FPC Gear Shop. We got a lot of cool new stuff, like check out this flag. I've actually got the come back with a warrant, welcome Matt out front too. Hopefully it won't have to be used, but yeah, no, we've got a lot of cool stuff coming, and there's also going to be a lot more content coming from myself and you, Craig. So definitely, guys, keep an eye on the channels.
Most definitely. Folks, this is the place to be. FPC is the group to be involved in. And by the way, before we go, I just want to make sure you let folks know. So, all rights, all the time. Explain to folks what that means.
So, it's not just about guns for us. This is about everything that it connects to. And I believe, and I'm sure a lot of you guys believe, that Second Amendment is the right that secures everything else. It's about everything adjacent to the Second Amendment. It's about your right to speech. It's about your right to be secure against, unreasonable searches and seizures. It's about everything. And our ability to control our bodily autonomy and our ability to direct our own destiny and be safe from unlawful exercises of power depends on our ability to take arms and give meaning to our rights. And so we think it's important to, make that clear for everybody.
Excellent. Matt, thank you so very much. Look forward to having you
on
the program again real soon.
Always a pleasure.
All righty, folks. That's Matt Larosiere, Firearms Policy Coalition Director of Legal Policy. All right, folks. Well, hey, that's going to be it for this episode of Coffee with Craig. We very much appreciate you all tuning in. We appreciate you liking and sharing the program and telling your friends about the Firearms Policy Coalition. We are the home in the fight for civil rights. Got to use them or you're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.